Namaste and welcome to Swadharma Academy. I am your mentor and today we are going to deconstruct one of the most pivotal concepts in Indian polity, the Basic Structure Doctrine.
Let's start with this powerful line from the Minerva Mills case. It perfectly captures the very soul of the decades-long constitutional tug-of-war we're about to explore. And what a struggle it was. This was a battle between two absolute giants of Indian democracy, the power of Parliament to make and change laws, and the role of the judiciary as the ultimate protector of the Constitution.
Now, at the heart of it all is one fundamental question, a question so important that it reached the Supreme Court within just 1 year of our Constitution being adopted. Can Parliament truly change any part of the Constitution, even our sacred fundamental rights?
You see, this is where the tension comes from. On one side, you have Article 368, which gives Parliament its constituent power, basically the power to amend the Constitution. But on the other side, you've got Article 13, which acts like a shield, saying any law that messes with fundamental rights is simply void.
So the whole legal fight really boiled down to this one critical detail. Is a constitutional amendment made under Article 368 considered a law under Article 13? As we're about to see, the court's first answer gave Parliament, well, almost unlimited power.
In the early days, the scales were tipped heavily in Parliament's favor, but as you can see from this timeline, the period from 51 to 71 was a constant back and forth, almost like a high-stakes chess match between the courts and the government. Let's break it down.
All right, so the first major test comes right away in 1951 with the Shankari Prasad case. This case was a direct challenge to the very first amendment to our Constitution, which had placed some limits on the right to property.
And the Supreme Court's ruling? It was crystal clear. The court basically said, look, there's a difference between an ordinary law and a constitutional amendment. They decided that Article 13 only applies to ordinary laws. This gave Parliament a green light, really, to amend any part of the Constitution it wanted, including fundamental rights.
So for over a decade, that was the law of the land. Parliament's power was seen as absolute. But then, the ground started to shift. By 1967, the judiciary began to seriously rethink this whole idea.
And this brings us to the Golok Nath case in 1967. Here, the Supreme Court did a complete 180. This wasn't just a small change in thinking, it was a total constitutional U-turn.
This time, the court said, hold on a second. Fundamental rights aren't just any rights. They gave them a transcendental and immutable position, basically saying they are sacred. And, crucially, the court now said that a constitutional amendment is a law under Article 13. Just like that, the door was slammed shut. Parliament could no longer touch the fundamental rights.
Now, you can probably guess what happened next, right? This was a direct challenge to Parliament's power, and Parliament was absolutely not going to take this lying down. It reacted, and it reacted fast. Parliament's big move was the 24th Amendment Act in 1971. This was a direct legislative counterattack. They went in and amended Articles 13 and 368 themselves to essentially erase the Golok Nath ruling. They wrote it into the Constitution, our power to amend is absolute, and Article 13 cannot stop us.
And that, my friends, sets the stage for the ultimate constitutional showdown. The ball was back in the Supreme Court's court. The 24th Amendment was challenged, and everyone held their breath for what would become the most important case in Indian legal history.
And what a case it was. We're talking about the longest hearing ever in the Supreme Court. A full 68 working days. And the final decision? It came down to this. A razor-thin 7-6 majority. One single vote changed the course of our country's history.
So what did the court do? It performed a masterful balancing act. First, in step 1, it gave a victory to Parliament. It said, okay, the Golok Nath case was wrong. We uphold the 24th Amendment. You can amend fundamental rights. But then came step 2, and this changed everything. The court said, but you cannot use this power to change or destroy the basic structure of the Constitution.
And right there, in that second step, the Basic Structure Doctrine was born. A brand new idea, a judicial innovation, created to protect the very soul of our Constitution. So of course, the big question is, what exactly is this basic structure?
Okay, think of it like this. The doctrine says Parliament can be the architect for our Constitution. You can renovate it, add new rooms, maybe even knock down a few internal walls. But you absolutely cannot touch the foundation. The core pillars must remain. And remember, this idea isn't written down anywhere in the original Constitution.
Now here's a key point, especially for those preparing for the mains. The Supreme Court has been very clever. It has never given us a final, exhaustive list of what is in the basic structure. It's an open-ended, evolving concept. But over time, through different cases, these are some of the core features that have been identified. These are the pillars that cannot be shaken.
And you can see exactly how this list was built right here in this table. It happened piece by piece, case by case. Kesavananda laid the foundation. Then, the Indira Gandhi case added judicial review. Minerva Mills even added the idea of Parliament's limited power to the list. And later, cases like S.R. Bommai cemented pillars like Federalism and Secularism.
So what does this constant evolution tell us? It tells us that our Constitution isn't some dusty old document sitting on a shelf. Not at all. It's something much more dynamic.
It's what legal scholars call a living constitution. It breathes, it adapts, and it changes with the times to meet new challenges. And the Basic Structure Doctrine is probably the single best example of our judiciary helping the Constitution to live and breathe, ensuring its core values are always protected.
And this brings us to our final, critical takeaway. It leaves us with a question that is at the very center of debates on governance even today.
On one hand, you could say the doctrine is the ultimate shield, a guardian angel protecting our democracy from being destroyed from within. But on the other hand, critics say it's a case of judicial overreach, of judges stepping into the role of lawmakers. Does it protect democracy or does it challenge it? There is no easy answer, and that is what makes it one of the most fascinating concepts in our entire constitutional framework.